Hello and welcome back to the channel for ongoing coverage of the Vallow Daybell case. Today we're going to take a little sidestep here. There's a legal issue that I think we all might want to familiarize ourselves with, so I thought I'd bring it to you today in an informational video. This is not something I'm saying is happening or is not, it's just let's get prepared in case it comes up. So what I want to talk to you about today is not guilty by reason of insanity versus incompetency to stand trial. These are two very different legal concepts, and I think it's important to get that clear before things progress. First, let's talk about not guilty by reason of insanity. This is evaluating by examining the defendant's state of mind at the time of the offense, meaning when Joe Bloggs murdered Sue Smith, did he know that what he was doing was wrong, was illegal, was morally and ethically and criminally wrong? If he didn't, and they can prove that, then he has a cause for a not guilty by reason of insanity defense. Not guilty by reason of insanity is not available in the state of Idaho as a defense. So Lori and Chad cannot plead NGRI, so it's not something we have to worry about. But it's very different from the next concept, which is incompetency to stand trial. Now this has nothing to do with the guilt or innocence of the defendant. This is not about what they thought when they were committing the crime or their motive or anything like that. This can be evaluated at any point during the trial process by court officials. An NGRI defense would be raised at the pleading. So, let's move forward. What does it mean to be incompetent to stand trial? Well, there are two parts to this. The first part is that the defendant has to be shown to have the ability to have a rational and factual understanding of the charges against them. Also, they have to have the capacity to consult with their attorney with a reasonable degree of rational understanding in order to form a defense strategy. Okay, that's a good starting point. There was a 1960 United States Supreme Court ruling that gave this a two-pronged approach. Number one, the ability to understand the charges, and number two, the ability to coherently assist in their defense. So that's what we're talking about today. Now, there are some important historical rulings that can play into this. The first one, in 1968, we have Wilson versus the United States, and the United States Supreme Court ruling on this case basically said that amnesia or memory loss does not automatically mean incompetency. What this means is even though you may not remember a criminal event or action that you took, that doesn't mean you don't understand a court proceeding and you can't take part in your defense. So I don't expect that to be something that we're going to hear about in this case. In 1972, Jackson versus Mississippi, a defendant found incompetent cannot be held indefinitely, only for a reasonable amount of time, not to be decided by the states. This means they can't go to court and be found incompetent to stand trial and be sentenced to a mental health care facility for the rest of your life. There has to be a reasonable amount of time for you to be held in that situation. In 1975, we have Jope versus Missouri. This is a really great case. If you want to dig into some stuff, go look this one up. I learned a lot from reading through this case file. There has to be a bona fide issue of competency raised by a court official. Right, either the judge or any of the parties involved can say, hey, we have some competency issues we might want to look at. Okay, but the threshold for competency is very low, meaning that it's pretty tough to prove that someone is incompetent to stand trial. They don't have to understand all of the finer points of a legal proceeding. They just have to be able to know where they are, who they're talking to, what's going on, the charges, what they mean, little things like that. Proving incompetency, there is a bar that has to be reached. There was a lot of discussion about this in this Jope versus Missouri case, so if you want to learn more, that's a great place to go read up. In 1993, we have the Godinez versus Moran case, and a defendant found competent to stand trial is also competent to make constitutional decisions, like if they want a jury trial, if they want representation, or if they want to go pro se. It means if you're competent to stand trial, you're also competent to make those decisions. Certainly, this is something that we've had recently come up in the Letitia Stout case, and that's a circus you don't want to miss. Moving on. Incompetency to stand trial is not terminal. The goal is competency restoration. This is a very important point, and we touched on it earlier. If you're found incompetent to stand trial, that is not a permanent thing, okay? Because part of the procedure that we're going to go through in a minute is to restore competency to the defendant so they can take part in the trial. So it's a short-term thing. Generally speaking, in most states, it's about 60 to 90 days where they'll do their initial treatment program, and then evaluators will come back to the court and say whether they find them competent or not. And that time could be extended on a case-by-case basis. The general evaluation process that's used to determine if someone is competent to stand trial includes a couple of things. First, there will be a forensic examination, and this is usually done by a psychologist or psychiatrist, and it can be done and is often done while the defendant is in a correctional facility, meaning they don't have to be shipped off to a hospital or a mental health care facility for this evaluation. Now, who orders the evaluation? The judge. Whichever party is concerned brings the information to the judge, and the judge will order the evaluation process to take place. Now, my main question is, who does this evaluation? And that's different in state by state. Some states have a Department of Corrections will have their own psychiatrist that will do it. It could be someone appointed by the judge. It could be the defense coming to the judge and saying, hey, I want to do the psychiatric evaluation for competency. And, we kind of go from there. But the first thing that happens, regardless of whoever is going to actually do the evaluation, is the general evaluation with a report that will then be turned over to the court. Now, these evaluations can include a lot of things. It's not just always sitting down and talking to the client. It can include interviews with friends and family, background, historical, quotes, even things that the defendant has said can come into play. And many times the examiner will look over the record of the case to get an idea of what's happening here. These evaluations will determine if they can understand the charges against them and if they can meaningfully assist their counsel. Some other things that are also assessed, and you know that this is going to be a big question if this comes up in the Vallow Daybell case, is malingering. Malingering is the psychological term for faking it. Can people pretend to be incompetent? Well, Letitia Stout tried that and it didn't go so well for her. She was unable to fake it well enough to convince the examiners that she was incompetent. The other thing that evaluators are going to look at is the likelihood of restoration. They will assess the defendant and say, can this person receive treatment, psychiatric treatment, that will restore their competency? Is that possible or not? In some rare cases, it may not be able to be done. So they will assess that, and that will also be part of their report to the court. The next thing that happens is the treatment plan. And the goal, as we said, is the restoration of competency. Now, they can do this through a bunch of different ways. Pharmacological and therapeutic, meaning maybe they need some sort of psychiatric medication, or maybe they just need a lot of therapy. This can happen in a group setting or private or a combination of all three. Generally, the treatment for someone who has been found incompetent will take place in a treatment facility or a hospital, and there will be ongoing evaluations that will be reported to the court. Once they find that the defendant has regained competency, the case will proceed. What if the evaluators find that competency cannot be restored? Well, this is very rare. Okay, so let's not worry about this too much. But there are some things in place that can happen. A civil commitment procedure, like they could just be committed to a mental institution, or a guardian can be appointed for them. That guardian would also then have the ability to have them committed to a mental health care facility. And the charges could possibly be dismissed, but again, that's a very rare occurrence. Probably not something we're going to have to worry about. Now, the general court procedure for this entire mess is, first, the judge's question period. In some states, and at his or her discretion, the judge can have a question period where they can talk to counsel, they can talk to the defendant, and they can try and make their own assessment. And then an order for evaluation will usually come for the judge. The judge may say, no, they're perfectly fine. Like the judge in the Letitia Stout case who said, nope, this is theatrics, let's move on. Or the judge can say, okay, there may be some issues here, let's get an evaluation done. Generally, what we see next is after the initial evaluation, we will have a fitness hearing in the courtroom where the judge will meet with both parties, they'll meet with any experts that talk to them, they'll hear their assessments, they'll be able to discuss it with the defendant, and then the judge can make a decision from there. The judge can decide to either continue with the trial and rule them competent, or send them off for treatment, and the treatment process will begin. Now, the judge's rulings can vary depending on the findings. If the person is found to be incompetent, the judge can rule that they're not criminally responsible for their crimes. That's not going to happen in the Vallow Daybell case, so that's not something to worry about. There could be an absolute discharge of the charges. Again, that's not going to happen here. There could be a conditional discharge, or the detention order. In most cases, you'll see the detention order, where the defendant will be detained in a mental health care facility or a hospital to receive treatment to try to restore their competency. And this is definitely not a get-out-of-jail-free card, so please let's not worry if this does come up. In most cases, competency will be restored, and then the defendant will continue to face the charges. Understanding what this is and what it's not is very important in case we start hearing this getting thrown around in this case. If anyone is found incompetent to stand trial, that does not mean that they get to walk and go home. It doesn't mean that they go to a mental health care facility for a couple months and then go home. It doesn't mean the charges will be dropped. It means at this current point in time, There is something going on with them psychologically that prohibits them from being able to understand the charges against them and the court proceedings, or be able to reasonably have a discussion with their own counsel to take part in their defense. And that means the proceedings will stop, there will be a stay or a suspension of the case, that person will then go to an evaluation process, the court will hear the results of the evaluation, and then decide if they need treatment or if the case can proceed. So that should be a good background to get you up to speed in case this is an issue that comes up in this case. Now you know basically what it means. The 4 historical cases that I listed earlier in the video, go ahead and give them a read. They're very interesting. We'll see how this whole issue comes about, throughout the course of our judicial history, what it means, and what to expect going forward. So if you have any questions, please leave them in the comments below, and I will try to answer them as best as I can. And let's keep an eye on the case. I'm not sure that this is going to be an issue, but I would not be the least bit surprised. So keep your eyes open, stay subscribed to the channel, hit that notification bell. That way if anything does happen, you'll get to hear about it right here. So thank you for watching. I appreciate the support, and I will talk to you very soon. Bye for now.